Hi, this is Kaushik Ranchod from the Ranchod Law Group. Welcome to our immigration show. Today, we are going to be talking about some case studies for J1 waivers, specifically the J1 persecution waiver, the J1 exceptional hardship waiver. Now, the first case study that we're going to talk about is the J1 persecution waiver, where the individual had Fulbright funding, U.S. government funding. So let's talk about specifically how we were able to get this case approved. So in this situation, when our client went back to her home country, she was interrogated and she was asked to provide certain information. Now, she didn't provide that information. She concealed it because she was afraid for her life. So in that situation, and she was also asked to provide certain information before she left, and she ended up leaving before and not providing that information. So when she came to the United States, she also was teaching, and that was another factor that the government wanted to persecute her for. So in this situation, because of her actions, because of her political opinion, she would have been persecuted. I'm happy to say that we were able to get the case approved, so she would not be persecuted if she went back to her home country. If you're a Fulbright scholar or received U.S. government funding, you may want to consider a persecution waiver. Also, if you don't have qualifying relatives like the exceptional hardship waiver, could be also a good option for you as well. And if this has been helpful, smash that like button. Let's talk about case study number 2 with an exceptional hardship waiver. Now, exceptional hardship waiver, you have to have a qualifying relative. So a qualifying relative can be your spouse who's a lawful permanent resident, or U.S. citizen spouse, or a child who's a permanent resident or U.S. citizen. So in this specific situation, the spouse was a qualifying relative. Now in this situation, the spouse was a veteran and also had a minor disability. They were relying on the insurance provided by the government, by the health care provided by the government, and if they were going to leave the United States, they wouldn't have access to the health care insurance and the healthcare programs provided by the VA in the United States. Also, our client's stepson could not leave the United States because the father would not allow the stepson to leave the United States, so we argued that as a form of hardship as well. We also argued that the client's wife and stepson relies on the income of our client, and so therefore that would be a form of financial hardship if they were separated as well. In this situation, we were also able to argue extreme emotional hardship. The wife was suffering from anxiety, from depression, due to the fact that the husband may have to go back home for 2 years. Now, it's important to note that mere separation is not enough, so it's something beyond mere separations, but in this situation, we were able to do that by showing that it went above mere separation, that the anxiety and depression were beyond what a normal separation would normally happen with normal separation. So I invite you to contact us, smash that like button, or post in the comments below if you have questions. And I want to thank you for taking time to watch the video to learn about the J1 persecution waiver, the J1 exceptional hardship waiver, how we were able to get these cases approved. Another point that I want to bring up is that I'm getting calls, which I feel very sad for the individuals who are calling, where they applied for the no objection waiver. They're on a Fulbright program, they received U.S. government funding, and they're getting their no objection waiver denied, which if you get U.S. government funding, usually you're going to get the no objection waiver denied. So I invite you to call us to learn more about that, to follow the right procedure, the right waiver filing according to your unique situation. And let's see you next week. Thank you. Bye for now.